Hello everyone, this is Anne from iPNOTE. Our trusted partner Wayne and I will be discussing an interesting topic today, information disclosure statement. Wayne, with his vast experience, will be sharing some insights of IDS. Wayne, let's start by understanding what an information disclosure statement is. Can you explain it to us?
Yes. And IDS stands for Information Disclosure Statement. It's a document that lists all of the prior, they call it prior art in patent law. In IDS, you need to list all the publications that you know of that are relevant to patentability of the invention. Now, it's especially important to make sure you at least list publications that you have published. And publications don't just mean published in a scholarly journal or published in a prior patent application. When you put up a website, you publish that website. And so your marketing is published. Anything that's available to the public is published. And that's what you list with the references so the patent office can find it. If it's not something that's in patent system, you need to actually attach a copy of that and we send it to the patent office.
I see. And can the applicant fill this statement himself, or it is better to ask the attorney to fill this form, so to speak?
Typically, in our law firm, we have the attorney do it. We want to make sure that some of the critical pieces are making sure we list. A lot of the references are patents, and we need to make sure we list it correctly so that it's easy to find and not confusing. The patents are the easier part. So if you're only listing patents, then you may be able to fill it out yourself, listing each of the parts, the patent number, when it was published, or when it was granted. I believe it's when it was applied for, who is the inventor or the applicant. But also the patent office wants you to put in what is relevant. Most patents are maybe 20 pages or so. Some patents are over 100 pages. So the patent office would like you to say, these figures are relevant to what I'm working on, or these paragraphs or these pages are what's relevant to what I'm working on. They don't reject your IDS if you don't put that. That's what they would prefer that you do.
So it is better to pay attention to any detail, every detail.
Yeah. And when it comes to citing a publication that's not a patent publication, it's something attorneys learn to do through law school, learning how to cite documents. And if an applicant is a PhD, they do that all the time because they're all about publishing and citing things. You want to make sure you're properly, one of the most critical parts is properly listing the date of the publication. With a patent reference, even though the patent isn't published when it's filed, they treat that filing date as the critical date rather than the publication date.
Got it. And I'm just thinking, can an information disclosure statement be submitted after the initial filing?
Yes, it is not required to be submitted with the initial filing. One of the questions is, when did you know about the reference? You actually have a duty as an applicant, and I, as the attorney, have that duty on your behalf as well, to disclose what we know to the patent office. And if we learn something while the patent is pending, then we need to disclose it to the patent office. This actually happens commonly when people are applying in different countries, because one country will be examining the patent application and their patent office will do research and say, we found these, we think they're relevant. Now, even if the applicant thinks they're not relevant, they really need to disclose it anyways, because somebody thinks it's relevant. So then you have a duty now to disclose it to the US, so I only know US law. And if you don't do that, you actually have 90 days to do that, or else you're going to have to pay a fee to disclose it. And not disclosing it has some severe potential consequences. So you want me to explain those, or
No,
or do you want a different question?
Yeah, it is quite clear right now. And as far as understood, it is better to provide it as soon as possible. However, it is better to include each detail, each pattern, so to speak. Am I correct?
Yeah. And you can file an information disclosure statement before the first office action. So that's the first response from the patent office, and not have to pay that fee. But after that first office action, if you file an IDS, you're required to state if you only learned about this within the last 90 days. Otherwise, there's an extra fee to file it. And the patent office isn't going to know that necessarily at that time. But when you're working with the patent office, everything you do can be scrutinized later and can be brought up in court as a reason to invalidate your patent. And that's especially true with an IDS. It's not what you put on there, it's what you don't put on there that could really hurt you. Especially if you have your own publication, something you've published, whether on a website or somewhere else, and you don't disclose that, and it appears that it's relevant to what you are applying for, then if you go to enforce your patent, then that's the first place the infringer is going to look. Can they find a reference before the filing date of that patent that you didn't disclose? If they can find that, then they get to go to the patent office and say the applicant failed in their duty and they lied to the patent office. Now, applicants, inventors, they don't know their duties necessarily, but even though they don't know it, it is their duty to disclose. So they call it fraud on the patent office to not disclose things you know. And that's a fast road to getting your patent invalidated after you've done all the work to get it through the patent office.
I see. Also, duties of inventors and applicants sounds like an interesting topic for discussion, because I agree with you that not many of them know about that. Anyway, thank you very much for your time and sharing insights. I guess that the basics of the information disclosure statement are understandable now.
You're welcome.